Good morning, everyone, and thank you for being here. We've got two bills on the agenda this morning. We're going to start with Senate Bill 250. Senator Chairman Hamrick is in a budget meeting. He's asked the Solicitor General for Douglas County, Brian Fortner, to come forward and present what appears to be a very straightforward bill. Mr. Fortner.
Thank you, Mr. Chairman. For those of you that don't know me, my name is Brian Fortner. I'm the Solicitor General of Douglas County and the President-elect of the Solicitor Generals Association. And Senate Bill 250 is a bill that deals with disruption of public schools. It's rare that I have an opportunity to talk to you about a bill that actually limits prosecution, but this is a limiting bill, but it does so necessarily. We had a state court judge in Douglas County rule that the statute as it stands today, 20-2-1181, is unconstitutionally overbroad in that it casts its net too wide and captures some innocent behavior. I think the specific example he gave was that what if a kid was coughing or sneezing repeatedly and that was disruptive to the school? Technically, that kid would be in violation of the statute. We did some research on the constitutional issues, and realistically, we're in agreement with the judge. The statute is too broad. So we met with some defense attorneys and came up with some language regarding the issue of intent, and that was what the judge had a problem with. And we came up with the words knowingly, intentionally, or recklessly to cover the scenarios when somebody would appropriately need to be prosecuted for disrupting public schools. So Senate Bill 250 is aimed at correcting the constitutionality problem with the statute as it stands today.
Questions for Mr. Fortner? Yes, sir.
What would be an example of a crime that
He's got to turn it.
what would be a type of crime that would not type of behavior like this that would not already be a crime?
Well, I think that there are situations where people knowingly disrupt schools in that they are unappreciative of what's taking place at school. We've had situations where parents have gone onto school property and wanted to yell and scream at certain teachers. It's not criminal trespass. I mean, we are talking public property. If you follow the right channels, it would not necessarily rise to the level of assault, but it does distract a teacher from being able to teach their students, or it causes other teachers and administrators to have to come out and deal with the situation. So a lot of times there are other crimes that may or may not be charged. For example, we've had fights on school property, some that didn't involve students, that involved parents on school property and things of that nature that cause teachers and administrators to have to rush out of school and deal with those problems. But a lot of times there are other crimes that are that can be charged, but there are some situations where the behavior is disruptive to the school where it doesn't fit into any other crime.
Well, I guess that's what I'm getting at. For instance, if the example where two parents get into a fight on school property, it doesn't make a difference where they got into a fight. They can be arrested for public affray or assault and battery or whatever might be the charges. Police are pretty inventive in coming up with charges against folks when they want to cart them off to the hoosgow. So what would be... But I mean, for instance, if parents oftentimes are pretty irate about things, something that's happened at the school or that sort of thing, and they come down to the school and they're not in any mood to, take no for an answer or whatever, and they get in some pretty heated arguments with the principal or school administration. We're not going to criminalize that necessarily, are we?
No, actually...
sometimes they're justified in being irate, as a matter of fact.
Well, actually, the statute 20-2-1181 exists right now. And as it exists right now, there's more opportunity for law enforcement to do, as you say, be creative and come up with ways to arrest people. This places limitations on law enforcement and prosecutors by making it specifically you're knowingly, intentionally, or recklessly disrupting that public school. Either it's your intent to do that, and you know that that's what you're doing, or you're recklessly doing it with some type of behavior, such as fighting on public school grounds, that actually disrupts the school itself. So I do think that there are many situations where there are other crimes that can be charged, but this statute was enacted, I think, to be specifically broad to protect our schools and to keep them orderly, because it's a tough job teaching the kids it already without having these outside problems. But what this bill does, it doesn't expand prosecution, it limits it to situations where specifically there's knowing or intentional or recklessness in disrupting that public school. So,
Mr. Franklin.
Thank you, Mr. Chairman. I'm kind of piggybacking on Chairman Knox. If a parent is concerned about a certain curriculum that really has nothing to do with learning how to read and write, but is really promoting a religious view of the school, possibly Messianic statism, and they go to object and are protesting that could easily be knowingly interfering with the operation. Just a simple protest. Another term for that might be petitioning the government for a redress of grievance, possibly. And I'm a little concerned with the whole code section that's in existence, that someone trying to exercise their constitutional right for redress of a grievance, something they feel that their tax dollars are being used for something contrary to what they believe in at that school, whether it's the existing law, which is unenforceable, or this bill that's trying to then make that existing law enforceable. How would you address that?
Well, first of all, let me say that the constitutional issues of the right to protest, I think this bill, if you're concerned about that, takes a step in the right direction, because certainly one has a right to protest. However, I don't believe one has a right to protest in a way that disrupts the school. For example, if you protest in a way that prevents the school buses from entering onto the property to release the children, I don't think you have the right to protest that's disruptive of the school. I mean, I think children have a right to an education as well. So I think that the statute, as we're amending it with Senate Bill 250, is going to restrict prosecutions more so than open it up.
I wasn't going keying in on that word disrupt on line 14, but the word interfere on line 15. And your objective could legitimately be to interfere with them teaching something contrary to your own belief. And it could be construed as that, and now a conscientious parent not wanting their child to be indoctrinated into a religious belief they don't hold could be deemed to be knowingly interfering with the operation. Interfere with the operation being that indoctrination into Messianic statism, say.
Well, let me answer that, Mr. Franklin. There's a big difference between protest and petitioning your government for redress of grievances under our Bill of Rights and interfering with the operation of an otherwise legal entity such as a public school. I don't in any way, shape, or form, again, just speaking for myself, I don't think anyone would ever deny anyone the ability to go ahead and express themselves legally in terms of expressing their opinion or their protesting of any practice whatsoever put forward by the government. As a matter of fact, I hope that they would. But of course, that, in my opinion, there is a line between expressing one's frustration, protest, lack of satisfaction, however you want to describe it, and then interfering with the ability of other citizens in their sending their kids in this situation to that school who don't have a problem with it. And that's the delicate balance of protecting the rights of the individual, as the gentleman I know knows better as well as anyone, while also protecting the rights of others who don't share that similar sentiment. That is a balance, and it is the ability to go ahead and maintain both of those rights, those sets of rights that I think we're looking at here. And some of it is discretion. Certainly, I mean that gets us back in any situation of prosecution. There's always that issue of discretion, and there are those who believe that, who maybe have a more jaundiced view of whether or not law enforcement will go ahead and exercise its discretion in a proper manner. There are those who believe that it will. There are those of us like myself who believe in trust but verify. Trust but verify, in order to do exactly what it is that the gentleman is worried about, and that is preserving the rights of individuals to express themselves, pursuant to our Bill of Rights. Thank you. Ms. Abrams. Nope. I'm sorry, Ms. Benfield.
Oh, I just have a quick question. I know this is existing law. I know it's existing law, but I wanted to get any insight as to why this is
misdemeanor.
I don't know why it was of a high and aggravated nature. I think in discussing the bill with various people, or the statute as it exists today with some school boards and things of that nature, that in its inception it was designed to be very broad and very protective of the actual school environment. And so I imagine that's probably why. But making it a misdemeanor of a high and aggravated nature raises the fine amount, as you know, but I'm not aware of any situation that I know of in my jurisdiction where anybody's been given an elevated fine over a normal misdemeanor fine for this offense.
Thank you.
Mr. Knox.
I want to get back to the issue. What constitutes disruptive? Is that defined anywhere in the code or in this section at all?
I don't believe it is. I think that's one of the issues that we're trying to kind of address, as the statute is meant to be extremely broad. So disrupt is very broad, or interfere with the school system. So I'm not aware of a definition that'll give you any real clarity as to that, what will disrupt or interfere. I think there's it can be so different depending on the situation at school that's taking place that there's no way to really define it.
Would you be happy with us just eliminating this section altogether?
I would not. Be it eliminating 20-2-1181.
Mm-hmm.
I would be very unhappy, because I think it would limit our ability to protect the schools. I think the school boards would be on board with me. This is a statute that we've run by representative of Gactel, and they have no problem with the statute either. I think that we're taking steps to limit it to when it's appropriate, and I think it's a good bill.
Are there any other witnesses who'd care to speak for or against Senate Bill 250?
Thank you, Mr. Chairman.
Hearing none, thank you, Mr. Fortner. What is the pleasure of the committee? Is there a pleasure of the committee?
Chairman,
Mr. Knox.
I'd like to recognize for a motion to strike the code section in its entirety.
Mr. Knox, let me see if we have a motion. We may get to the point where, if we do have a motion, or if we don't have a motion, that your action may or may not be necessary. But let me ask the committee, this would be the time for a motion, if there is a motion.
I'll move to pass.
Ms. Benfield, I almost said Ms. Stuckey. Ms. Benfield moves to pass. Is there a second? There is a motion and there is a second. Are there any amendments, Mr. Knox?
Mr. Chairman, I think my amendment would be to, on line 10, to substitute for the word revising between by and code, and substitute the word striking. And then on line 13 through 17, striking all that between 13 and 17.
And I assume you'd want to put the word reserved
Yes.
in there.
Thank you.
Is that in the nature? I assume that's in the nature of an amendment officially.
Yes, sir.
It is in the nature of in the nature of an amendment by Mr. Knox. Is there any discussion on the amendment, Mr. Everson?
I was going to make a motion to pass, but Representative
Thank you, Mr. Mangum.
the author of the amendment, could I ask him the basis for this?
Could you pull your microphone toward you? Let's see which one I've got here.
The author of the amendment, could I ask you the basis of why you are doing that? I was trying to get up to speed on it. I left out of the room, unfortunately. And I just wanted, why you want to strike the entire.
I think the issue is that there's a recognition by Prosecutors Association that that the law as it's currently written is too broad. There's been at least one, according to them, there's at least one decision by a Superior Court saying that it doesn't meet constitutional muster because you can't really tell what it is. It's so broad that it could encompass any kind of a behavior or activity that could come under and be considered to be a criminal act. I think by making the changes that we're making here, that is adding the terms knowingly, intentionally, and recklessly, doesn't really solve that matter. The issue still is whether or not the issue of disruptive is the problem. What's disruptive activity or behavior? And if it's not one that's criminal as it is, I'm not sure why we need to address it. It seems to me like it ought to come under other matters. So this doesn't really do what I think it is that they're trying to do. Simply saying that it has to be knowingly, intentionally, or recklessly doesn't really add much to it. You always have to prove intent. In a criminal matter, if you don't have intent, it's not a criminal matter.
Oh,
I think it's
sorry.
a bad precedent for schools to have the authority to have a parent arrested because the parent comes in and maybe raises their voice and or wants to argue the point too long. I just think that shouldn't be a crime. I think they should have some other way of dealing with those kind of situations. And that may be that they have to have the school officer come and say, look, you made your point, you need to go ahead and leave. At that point, if they're not, then there is a criminal issue because he's told them to leave and they're not following the directive of an officer. Or if a police officer is called. So I think that's the way that ought to be handled. We shouldn't make another crime out of parents coming to a school and trying to deal with issues that they have a legitimate interest in.
Follow up.
Sure.
And Legislative Council has attempted to without success, defining the words disruptive and what constitution. I know that's a very broad. I can even think of some very broad. But has there been an attempt by Legislative Council to define disruptive behavior?
Ms. Travisano has a comment.
Oh, well, I was just going to comment on the issue of what you would be doing is repealing 20-2-1181, and if you were to do that, then there would need to be a cross-reference check in the code to see if that code section is mentioned anywhere else, and correct it accordingly. With respect to the issue of defining disruptive or disrupt, it's I'm not the drafter of this piece of legislation, so I haven't researched that.
To summarize where we are, and I think we do want to move on because we do need to get to 151 one way or the other. To summarize, the law as it is right now is overbroad. That's universally accepted. What Senate Bill 250 intends to do, or the intent behind the legislation, is to narrow that sufficiently so that there is clear direction on the use of the statute. And that's what's being brought forward by Mr. Hamrick and sponsored today by his solicitor in Douglas County, Mr. Fortner. Mr. Knox has presented an amendment to strike the entire code section, and the way I would describe it is that in Mr. Knox's opinion, is that the law, with the proposed bill, even with its narrowing, is still overly broad. I think that's where we are right now in a very brutally, hopefully objective description of where we are on the issue. We have, I'm sorry, there's Mr. Ramsey.
I just, in response to Representative Mangum's question about defining disrupt, I just want to make the point, and to your point, knowingly, intentionally, and recklessly are all words with significant case law, both in the civil and criminal context, that would at least give the court guidance to know what disrupt means. I mean, knowingly, intentionally, or recklessly are words that are used throughout statutes, and it certainly, while it doesn't define disrupt, as Representative Mangum asked, it does provide significantly more guidance than current law, which is the problem we're seeking to address. So,
I would note, counsel for the committee has just informed me there is a case coming out of the Supreme Court of June 2nd, 2008, in re D, capital D period, H period, where the court has said that we concluded that the natural and obvious meaning of the language used in the statute was sufficiently definite to warn persons. And what they're saying, we reached the same conclusion in this case and conclude that the phrase disrupt or interfere with the operation of any public school contains words of ordinary meaning that give fair notice as to the statute's application. Accordingly, we affirm the trial court's ruling that the statute is not unconstitutionally vague. Maybe overbroad, but it wasn't vague in terms of the definition of the use of the word disrupt. That's where the court is right now, and I'm simply reading what's on the computer. I would like to proceed with the amendment if we could. Mr. Knox. Well, we actually already have a substitute amendment. I'm not sure if we can go to a third-degree amendment. We'll see how the Knox. I've never done that, but we'll go ahead and see how the Knox amendment does, and then we'll move on from there if there's another amendment.
Instead of or.
right now we have an amendment. We have a motion. We have a second. We have an amendment by Mr. Knox that proposes to essentially strike lines 9 through 17 and doing away with 20-2-1181. All in favor of the amendment, please signify by raising your hand. Strange bedfellows. All opposed? And the amendment fails. Are any further amendments?
Yes, sir.
Mr. Mangum.
I'm not a criminal lawyer, but I do believe that if you raise the standard and say it instead of or to make that and, I think Mr. Knox said it, but I don't believe that it is implicit in this language. When you can knowingly, but you got to intend. I knowingly throw the ball, but I didn't intend for it to disrupt. I'm just giving you a very simple example. So I think if we put knowingly, intentionally, and recklessly, if I put an and rather than an or, particularly with knowingly and intentionally, implicit in every criminal law is that you intend to do something, but I can intend to do something, but I don't intend it to the act to be.
Just to make sure that's clear, Mr. Mangum, if the gentleman's amendment is and, then for purposes of statutory interpretation, it will be knowingly and intentionally and recklessly, which means that in order to go ahead and prosecute under the statute, the prosecution will have to show that it was knowingly and intentionally and recklessly if you substitute the word and for the word or in line 14.
I want to correct that.
Okay.
Knowingly and intentionally or recklessly, because I believe recklessly can stand on its own.
Mr. Fortner, do you have comment on that?
As it was recently stated, we would have no objection to adding that language, knowingly and intentionally,
Yes,
or
sir.
recklessly, separating the two, because I think that's what we're really going after.
Any further discussion on the gentleman's amendment? Ms. Byrd.
I don't know if this is an amendment or not, but we're on line 17 where it says misdemeanor, is there any reason why we're making it a high and aggravated as opposed to just a plain misdemeanor?
We are not making it a misdemeanor of a high and aggravated nature. That's existing law. That is existing law, and it's subject to amendment just like anything else. But let's go ahead and focus on the Mangum Amendment right now. The Mangum Amendment as proposed is on line 14, it shall be unlawful for any person to knowingly and intentionally or recklessly disrupt or interfere, et cetera, et cetera. Is there any objection to the amendment? Is there any objection to the amendment?
Wait, I'm sorry. Objection to the Mangum Amendment? Yes.
Correct. Is there objection to the Mangum Amendment?
I object.
Gentlelady objects. On the gentleman's proposed amendment on line 14, it shall be unlawful for any person to knowingly and intentionally or recklessly disrupt, etc. All in favor of the amendment, please.
Wait, I'm sorry.
I'm going to call for the vote anyway. On that amendment, on line 14, it shall be unlawful for any person to knowingly and intentionally or recklessly disrupt or interfere, etc. All in favor of the Mangum Amendment, please signify by raising your hand. Opposed? The Mangum Amendment is adopted. Are there any further amendments?
Yes.
Ms. Byrd.
I would like to make an amendment on line 17 where we would strike of high and aggravated nature and put a period right after misdemeanor.
The amendment by Ms. Byrd on line 17 has the effect of changing the underlying crime from a misdemeanor of a high and aggravated nature to a misdemeanor. Is there any further discussion on the amendment? Mr. Fortner, let me ask you a question about that. Is that on this particular, this strikes me as a statute that, when it was written, whenever that occurred, it probably came in quick. Maybe didn't have as much fly specking as it should have. I don't know, and I'm not going to editorialize one way or the other on it. In general, in terms of the cases that you prosecute in state court in Douglas County and Mr. Spahas in Henry County and so forth, and across the state, and my own solicitor Barry Morgan in Cobb, this particular type of misdemeanor as it relates to other misdemeanors of like kind, if that's even the proper description. Is a misdemeanor of a high and aggravated nature on this particular type of offense consistent with other crimes that you see in the code that you prosecute in state court?
Well, I think that with this particular type of offense, there can certainly be situations where it would be of a high and aggravated nature, where it would be serious enough where we would want to punish it more severely. I can tell you that in prosecuting these cases, typically the issue that you're looking at with high and aggravated is a fine. And we've not given anyone an elevated fine above a normal misdemeanor fine on one of these cases right now, but I can tell you that in talking to the school boards, they consider this to be a very important statute that they use to protect their schools. And I can certainly see certain circumstances where people were disruptive of public schools that would be high and aggravated.
Talk to the committee for just a moment about the general, if you were to get to a point of incarceration as it relates to a misdemeanor versus a high and aggravated misdemeanor, what are the practical differences?
The only practical difference, Mr. Chairman, is the good time credit formula. As far as 2 for 1 and what have you, high and aggravated is treated differently. That's when actual jail time is imposed. Really that is the only distinction other than the possibility of the elevated fine.
Thank you. I appreciate the clarification, just for my own edification. Ms. Byrd has presented an amendment which on line 17 would place a period after word misdemeanor and strike the words of a high and aggravated nature, thereby changing the existing law from a high and aggravated misdemeanor to a misdemeanor. Is there any further discussion on the amendment? Seeing none, all in favor of the Byrd amendment, please signify by raising your hand. Opposed? And the Byrd amendment is adopted. Are there any further amendments? Seeing none, there's a motion, there's a second. Any further discussion? Seeing none, on the motion of do pass Senate Bill 250 as amended, Ms. Travis, is it of any import to you whether we do it by substitute as amended or just do it as amended?
You're doing a substitute.
We're doing this. You heard the lady. I know I did. Of do pass by substitute as amended. All in favor, please signify by raising their hand. Opposed? And the motion is adopted. Thank you. So much for a simple 5-minute bill. Senate Bill 151 by Chairman Wiles. Mr. Chairman, thank you for your patience. From now on, Mr. Hamrick will have to show up for his own bills.
He's over.
Lessons learned the hard way.
Yeah, I think so. I think he's over in presenting budget committee like I was going to be, but I decided to stay because it was a simple little bill. And
that's right. Simple housekeeping measure, just levels the playing field.
That's, yeah. No opposition on any side.
Right, there you
that
go.
Kind of thing. Well, I do not bring you a simple housekeeping bill. I do not bring you a bill that levels the playing field. I bring you a bill that has worked its way through the Senate committee, Special Duty Committee, and has worked its way through 2 subcommittee meetings of this committee. And I appreciate, as I've expressed previously, the time that this committee, through its subcommittee, has spent on this bill. This is an important bill. And succinctly, what it deals with is the ability to provide basically victim impact testimony in a form other than live. And we're going to hear, if you so see, I'm sure you have several witnesses, Mr. Chairman, that testify of the actual victims and their experience in testifying in cases. But from my viewpoint, what it does, and the district attorneys, David McDade is here, can speak to it more because I do not practice in the criminal area, and so I'm just an advocate, not a practitioner. It allows someone to make a presentation to the jury to give the full impact of this crime on their family and to humanize the victim. Quite simply, it is the hardest thing that most of these family members have ever been asked to do. And you will hear the testimony, and you will, I think, when it's concluded, those that have not heard it will understand why. And this bill, because it deals in part with the death penalty, has received a lot of vetting, and every moment we move through this case, and quite honestly, every different attorney in the Legislative Counsel's office that touches it has a little different point on it, and when we make a change in subcommittee, then we get another thing. And in fact, Jill Travis has made some recommendations today that David McDade and I think have agreed to, but the subcommittee made some changes that some of the witnesses want to talk about. They have some problems with. But the bottom line is the conflict we have, and the council will be much more available to discuss it, is in our Constitution, you have the absolute right to confront your witness against you. And by providing the videotape, your first statement will be, how will you confront? Well, the witness will have to be available to testify if the defense so desires to call the person to testify live. And I guess the other question would be, well, why don't you just testify live? Well, it's very, very hard. And understand that in a death penalty case, they are reading a court-approved statement. You don't get to, in a death penalty case, walk in and just start testifying about the impact of this crime on your family. You have to actually prepare a statement. The judge vets it, as does the defense counsel and the defendant. And then, in fact, in death penalty cases, you actually have to read it outside the presence of the jury before you give it, so the judge can be sure that you can, in fact, give it without showing emotion, that you can make it through, which is very hard to do for many of these witnesses. And so this allows, most likely, for a videotape to be prepared if the person can't do it, and play the videotape with that victim witness sitting in the courtroom, or in the current bill, available by teleconference to be cross-examined. That might be troublesome. We'll listen to Jill on that. But the bottom line is, we're simply trying to make it easier for these witnesses to testify, but not in an unconstitutional way. Very tough stuff to do. Very, very tough stuff. That's why this one has been lawyered a lot, and we should expect it to be lawyered a lot. I've just sort of given you the rough outline. I'm going to let, if you could, Mr. Chairman, let Mr. Dade and then the witnesses, they're the lawyers and they're the victims, families. And
Mr. Chairman, let me ask you just one question, and
Mhm.
if you want to defer, that's
Okay.
certainly fine. No problem. On page 2,
Mhm.
and I know we're going to get to an issue in section 4, beginning on line 35, about whether or not that paragraph is consistent with Sixth Amendment
Mhm.
protections, and it's a good conversation to have, a necessary one. In the paragraph before that, beginning on line 31, the admissibility of the evidence described, etc. Sole discretion of the judge, permitted only in such a manner as allowed for cross-examination by the defendant, and to such a degree as not to unduly prejudice the defendant or unduly burden the witness. The language "unduly burden the witness." If the witness is up there and they've put themselves in that position, I mean, that's the place they want to be. So is that, by definition, an undue burden on them if they're? And that's where we're going with the entire intent. You see where I'm going?
Yeah, I see where you're going, and we haven't focused on that part, so I might have to defer on that.
Okay, that's fine. I just
And Jack Martin's here, and he has raised to the subcommittee many issues, and the real question, I had some, as I expressed to the subcommittee, I had some issues because I will tell you, this is the toughest thing most people are asked to do, and on line 37, where you deal with causing the witness severe physical or emotional distress or trauma. That's a standard the judge would have to find. But when you cut to the chase, the Superior Court judge, is still going to have tremendous discretion. And I think that's also essential to the statute being constitutional. Is we entrust our Superior Court judges, we give them great direction, and we give them training, but ultimately we give them discretion that they have to make sure that the trial is constitutionally fair. But the Supreme Court of the United States has said these statements are allowed. And so it's a balancing act. And my bill, the first part, Section 1, simply deals with another way of delivering this testimony. And that's what it deals with.
Thank you. Thank you, Chairman Wiles. David McDade is the DA from Douglas County, or the Douglas Circuit.
Good morning, Mr. Chairman, members of the committee. My name is David McDade, and I am the District Attorney in the Douglas Judicial Circuit, which is Douglas County. First thing I'd like to do is thank the members of the subcommittee that heard this bill. It was one of the most helpful, compassionate hearings I've ever participated in my life down here. Senator Wiles is to be commended for sponsoring this legislation, and this committee is to be commended for taking up this piece of legislation. This is truly a piece of legislation that has the ability, if passed, to help victims of some of the most horrendous crimes you will ever see in your life. Seated in the committee room behind me, and those of you on the subcommittee met these folks, and you understand their testimony, and I mean testimony in every sense of that word. Seated behind me on the front row is Miss Claudia Barnes. Miss Barnes is the widow of Judge Roland Barnes, the judge that was assassinated in the Fulton County Courthouse murders, and she is here to offer her guidance and testimony. Seated to her left is Miss Kelly Wiggins. Miss Kelly Wiggins' sister Marie was murdered in a double homicide in Douglas County that I prosecuted. She, like Miss Barnes, is here to offer support and insight into what a victim truly suffers when they attempt to testify in a capital case. Seated to Kelly's left are Linda and Wayne Brown. Linda and Wayne lost their daughter in a double homicide in Cobb County that many of you heard. It's described as the realtor ladies that were murdered in Cobb County. They lost their daughter, and they're here to tell you about their experiences in trying to offer assistance in the judicial process and the roadblocks they encountered and the difficulties they encountered. Seated to Wayne's left is Miss Jesslyn Dorsey. Miss Dorsey lost her only child in a horrific murder in Cobb County, and she too is here to explain why she supports this piece of legislation and what it does. I ask you to listen to these people. Senator Wiles did an excellent job. Not that he needs me to say that, but he did an excellent job outlining what the thrust of this bill is. I'm going to speak primarily to its application in death penalty or capital cases. For those of you that have never practiced in that area, it is a unique part of the law and has a number of unique, very important guidelines, rules that must be followed to protect the defendant's rights. Believe it or not, I agree with that. In a death penalty case, the trial is a two-phase trial. The first portion of the trial involves the prosecution's requirement to prove the defendant's guilt beyond a reasonable doubt. That's the first phase of the trial. And then, and only then, if the defendant is found guilty of the murder in a case for which the state is seeking the death penalty, we go into a second phase of the trial. It's called the sentencing phase. In the sentencing phase, the only issue for the jury to determine is what is the appropriate punishment to be imposed in a capital case. The jury is required to make a finding of aggravating circumstances before the death sentence can be imposed, or under current law, as of today, maybe going to change tomorrow, but as of today, before a life without parole sentence can be imposed, an aggravating circumstance has to be shown. When we're in the sentencing phase of a trial, the defendant is allowed to offer pretty much unchallenged unrestricted evidence in his or her phase of the trial as to what they believe is mitigation, reasons why the defendant shouldn't be sentenced to death. And pretty much, and Mr. Martin is here and he can disagree with me, but I don't think he will, a defendant is given unfettered access to the jury as far as what it can present, pretty much. A defendant can put his mother, his sister, his children on the stand to literally beg for mercy. And as horrible as it sounds, I don't disagree with that. I don't. If we're seeking the death penalty, I think the defendant should have the right to offer whatever he wants to, and they do under current Georgia law. However, when it comes to victims of crime, they don't have that right. They absolutely do not have that right. Senator Wiles explained it very well. Under current law, the victim's family, or anyone that cares about the victim that wishes to testify in the sentencing phase of a death penalty trial, is permitted a very limited, very restricted, almost inhumane method by which they have to come in and try to convey to the jury their sense of loss and grief. A victim offering a victim impact statement in a death penalty case must offer that statement in writing to the court in advance of their testimony. The judge, the defendant, defense counsel all have the opportunity to edit it, argue over the words, limit it, restrict it, prohibit it from demonstrating emotion, and then the victim's family member is directed to come into the courtroom and simply read that scripted statement. And in most cases, they are instructed under the penalty of being excluded from testifying. They are instructed that they cannot show any emotion that would unduly prejudice the jury. Now, you're going to meet from several people on this front row who have experienced some forms of that horrific process. They will describe to you what it is like to be the parent, the spouse, the loved one of a person who was murdered, and they have sat through weeks of trial, and then they are told that the only way they can demonstrate their sense of loss is to read a prepared statement. What you will also learn from these witnesses is that many, many people, when they're called upon to testify in such an emotional setting, simply cannot do it. If I were asked to describe, and I pray to God that none of you were ever asked to do what they were asked to do, but if I were asked to come in and describe the death or murder of my daughter, I get choked up just thinking that thought. And they are instructed that they cannot show emotion when they do that. What Senator Wiles' bill does is it offers a mechanism whereby victims are given an opportunity to at least prepare a statement that is recorded in some fashion prior to testifying, and they prepare the statement in a controlled environment, in a more loving environment, outside of the courtroom. They prepare it on tape. And then it is still vetted to the defense bar. It is still vetted to the judge. The court still maintains absolute control over the process. But that victim is allowed to at least prepare that statement when they can control their emotions and when they can at least have support around them to do it. And then that statement is to be brought in, and that statement is to be played for the jury with the proponent of the statement in court to be cross-examined. We're not asking that you limit the defendant's ability to cross-examine or the judge's discretion in how it's presented to the jury. You simply are, if you pass this piece of legislation, going to give victims an opportunity to convey to the jury, under the guidelines that exist, as much of their loss as they can. I urge you strongly to pass this piece of legislation. There are a couple of issues that have been raised since the subcommittee's good work. I've spoken to Mr. Martin. I believe we're in a position to offer to the full committee language that we believe will address the issues that have been raised. I will briefly touch upon them if you find it appropriate to do so now, Mr. Chairman. At lines 18 and 19, and this came out as a result of Representative Benfield's issues about the number of witnesses. The victims that are in the court, that are in the room this morning, Mr. Wayne Brown specifically is just very much asking this committee, and he will articulate it for you, that you don't limit at least the immediate family members. Give at least the immediate family members the right, unfettered, to testify. If you want to limit the number of members of the extended family or to the public, he's going to urge you strongly to at least give the immediate family members the absolute right to testify. And I've discussed it with Mr. Martin, and I'm not speaking for him, but I don't believe we're going to have any disagreement over changing the wording in some way, and we would look to the committee for the actual wording if you have no objection to it. Mr. Brown can speak to that much more eloquently than I can, but that's on lines 18, 19. The other area that has been raised by Leg Council, and it was raised in subcommittee and it was discussed in subcommittee at great length, is the case that was Maryland versus Craig, that those of you on subcommittee recall. That's the federal case where the courts addressed, is it constitutionally permissible in light of the right of confrontation to have a procedure where a witness is testifying outside of the direct presence of the defendant. Maryland versus Craig offers guidance in that area and says that it is constitutionally permissible to do so with certain guidelines and restrictions. The language that's in section 4 at lines 35 through 45 are where this issue is framed. And it would only come up in the issue that begins at line 39, where we start talking about a teleconference or other electronic means or a statement made via speakerphone with an attorney's verification of the speaker's identity. We have no objection if the committee's preference is to leave it in. We're comfortable with addressing the constitutional issues that may arise. That's actually Mr. Martin's language that he offered the subcommittee in response to Maryland versus Craig. However, if you want to take a very constitutionally careful approach to the bill, as Leg Council, I think, maybe has encouraged at least a conversation about, we would have no objection if on line 39, after the word statement, comma, where it says a teleconference or other electronic means, down through line 41, the word identity, comma, is struck. That would simply remove that scenario from the analysis. And then you would need to strike at line 44, where it begins with the word where, through line 45, the word cross-examination. Leg Council can certainly speak to that. Mr. Martin can certainly speak to that. But if you eliminated the teleconferencing, that would eliminate any issue whatsoever about it being outside the defendant's presence. So long as you leave the rest of the bill substantively pretty much intact, I don't think that we're going to have any issues that we can't resolve at this point. I think they've all been very carefully vetted, and I would certainly entertain any questions.
Thank you, Mr. McDade, for your testimony, and appreciate your general approach on the Sixth Amendment issues. Following up on that line, I realize that the seminal case is Maryland versus Craig. Of course, that was a child molestation. To your knowledge, and we will have a conversation about that to make sure that the bill is as tight as possible. Cases that have been spawned from Maryland versus Craig, can you speak to any line of cases that apply, that use Maryland versus Craig as a foundation, that apply in death penalty cases and or in murder cases, that give us guidance as to what it is that we truly need to do in order to satisfy Sixth Amendment considerations?
Mr. Chairman, the cases that I'm familiar with all deal with child abuse, child molestation issues, because that's where I think the cutting edge in the legislative process began, addressing a child's needs to be protected. There's actually a statute in place that allows for a child hearsay statement in certain child abuse cases to be admitted, where the child maybe makes an outcry to a third party, and that third party is allowed to come in and testify so long as the child is subject to cross-examination, should the defense wish to call them. So there's ample general law that supports the proposition of that framework. I personally am not aware where it has been extended into a capital case situation that didn't involve a child.
My sense of it is, and this is just for discussion purposes, my sense of it is if Maryland versus Craig is fairly definitive in terms of what's necessary in order to preserve Sixth Amendment protections, my sense of it is that and that's a child molestation case, which of course is extremely serious situation, but it wouldn't be unreasonable to say that, of course, a capital murder case is more serious. They're both serious, but of course, if we're going to give that consideration to a child molestation case, I guess the rhetorical question I would ask is, well, how could we not do that then in a murder situation, in a murder trial, and certainly in a death penalty situation? That's just something I'd ask you under no duty to answer, and that's I think a legitimate question that I have on it.
Mr. Martin and I will probably agree on this. As shocking as it may be to some of you, I will concede that in capital litigation, the level of scrutiny is always higher, regardless of how the constitutional framework may underpin another area of the law. When you get into capital litigation, the scrutiny and the examination of the issues is on a different plane. Mm-hmm. And I would rather that we err on the side of caution in this regard and remove the language unless there's complete agreement from all parties that the out of the presence of the defendant language is not going to be constitutional muster. I would rather take that fight on another day in a separate bill, to be quite honest with you. This is going to be, if I may continue, Mr.
Sure.
Chairman, so that you will have a better framework on understanding this. Mr. Martin and I have both tried a tremendous number of death penalty cases. Mr. Martin, and he will speak to this, I hope, Mr. Martin recognizes, and we've discussed this ourselves, that a number of capital attorneys will embrace this legislation for their own reasons. If a person is representing a capital defendant and a victim is unable to testify other than through these means and the judge authorizes it, it benefits the defendant, believe it or not. If the defendant has a procedure available where a victim is testifying from a videotape or from an audio tape, they would rather have that in most cases than the victim in the courtroom demonstrating their emotion. So to his benefit, to Mr. Martin's benefit, you separate the law students from the lawyers when somebody like Mr. Martin recognizes that this bill has benefits to them. I fully concede that. On the other hand, I will tell you the reason we're able to reach compromise and I guess a consensus amongst us is those people sitting on that front row. They deserve as much dignity and compassion in the process as we can possibly afford them. Kelly Wiggins will tell you that her father, who sits behind her in the second row, and her mother could not compose themselves to the point to where they could testify in front of the jury. My nickname for her father, and please bear me a moment of personal indulgence, his name is Grumpy. He smiles when I say that now. His demeanor throughout the trial was incredibly, understandably, he's reliving the brutal murder of his daughter. Do you think he could get on that stand and testify? No. He doesn't know this. He's going to hear it for the first time. We had people in the courtroom whose job was to tackle him if he climbed over the railing during the trial. One of those guys is standing right over there. That was his job throughout the trial. So it offers benefits to both sides is what I'm trying to tell you.
Further questions for Mr. McDade from members of the committee?
Thank you, Mr.
Seeing none, thank you. Mr. Martin, I'm going to call you up next in the interest of parity. If you'd introduce yourself.
Yep. Thank you, Mr. Chairman, members of the committee. I'm Jack Martin with the Georgia Association of Criminal Defense Lawyers. As I said before the study committee, we support this legislation. We have been trying to work with Senator Wiles and Mr. McDade and others to try to perfect it, to try to strengthen it. And I think Mr. McDade is correct. Both sides in these types of cases want the family, if they're going to testify, and the law allows them to testify, to be able to do it in a dignified way. in a way that they can get out what they want to say. And it is always, I don't care if they're reading from a script or not, it's always emotional. And it'll always break your heart when you hear that testimony. And we're not trying, the law's changed, for years that wasn't allowed. Supreme Court changed it, it is allowed. All we're really trying to do is be able to do it in a dignified way that protects constitutional rights. And quite frankly, we have a bill that will pass constitutional muster. And we made a lot of improvements during the study committee, subcommittee process. Let me just point out just a little bit of the history of this from a constitutional perspective so you understand why it has to be the way it is. When Payne versus Tennessee, which was the Supreme Court case that allowed victim impact evidence, before that Booth versus Maryland was the case. It said it was absolutely prohibited. They said, well, we'll allow it as long as it's done in a way that doesn't unduly prejudice the process. And if it in any way becomes too emotional, too unduly prejudicial, then it'll be a due process violation. And the Georgia Supreme Court, when what happens is the Georgia Supreme Court originally held it under the Georgia Constitution, this type of testimony wasn't allowed. But after Payne versus Tennessee and this legislature passed a bill allowing it, they held it was constitutional in a case called Livingston. I will point out that in Livingston, however, they said that the reason that we hold it as constitutional is because there are certain protections in the bill, one of which gave the judge the power to actually exclude this testimony if he thought it was unduly prejudicial, or the power to limit it or structure it so it wasn't unduly prejudicial. Now that's the current holding of the Georgia Supreme Court. So that's the basis that the Georgia Supreme Court held it was constitutional, is because the judge had the power to control it. In a subsequent case, the Turner case, the Georgia Supreme Court said this is the best way to live up to that standard. And what we'll do is we'll have the statement written out. We'll have the witness actually practice the statement so the witness can give that testimony without crossing any constitutional grounds. For example, Payne versus Tennessee says it's absolutely prohibited under the Constitution for a victim witness to state their opinion about the defendant or what the sentence should be. That's constitutional law. If a victim impact witness on the stand starts to talk about what they think the sentence should be, that's a constitutional violation and the whole case blows up. So this was a way to protect victim witnesses in that emotional context from crossing the line. The purpose of this statute, and I think it is a good purpose, is to allow in certain situations where a witness, first of all, they'll be reading from a script, and it's not just a script. These do not become devoid of emotion. They talk about the cost, how it feels to not have their loved one at Christmas time. I mean, they can talk very emotionally about things as long as they don't cross the line. What this bill will allow, and I think the good purpose of it, is some situations where, like Mr. McDade mentioned, that the witness, the grandfather, just could not do it in court with the defendant there, to have a procedure where they could do it by videotape, and they would present the videotape as long as it was subject to cross-examination. Ladies and gentlemen, I know of no criminal defense lawyer that ever really cross-examines one of these statements. I mean, what are you going to do? I mean, you're going to challenge the pain that they felt. That's just a losing proposition. So, but constitutionally, you have to have the right to do that. And by the way, this bill, why that's so important, this bill includes non-death penalty situations where a victim might claim an excessive loss in a burglary case. Perhaps they had been compensated by insurance. So a lawyer might, in that situation where restitution is at issue, want to challenge what the victim says in a non-death penalty case. So you have to have that right to cross-examine. So when the bill first came up here, one of the problems we had, one of the concerns we had, was that it took away the discretion of the judge to bar the testimony altogether. And that was one of the points that the Supreme Court made in Livingston as to why it should be constitutional. I'm willing to give on that, and I think it's okay for us to give on that as long as the judge still has the discretion to limit the number of the witnesses and the discretion, of course, to make sure and ensure under the Turner case that the statement is consistent with constitutional limitations. I wonder, we say the immediate family, and that's something Ms. McDade and I talked about, and that seems to be a reasonable compromise. One, as the statute originally said, would be anybody any family member, member of the family of the victim or any other witness having personal knowledge of the victim. I mean, that could go on forever. So I'm willing to say any immediate family member should have the right to give this type of testimony. But I will just give this one caveat to that. That is not what the Supreme Court said in Livingston was one of the protections that makes the statute constitutional. I think as a general matter, I've never had a judge deny an immediate family member to give the testimony. What becomes a problem is when you have aunts and uncles and other people, and it becomes just too much. Just in the spirit of compromise, I'm willing to agree that we'll go with immediate family members if that satisfies the problem. To deal with the Maryland versus Craig problem, and I am confident. Well, let me just back up about Maryland versus Craig. There was two cases: Corey versus Iowa, and then Maryland versus Craig. And Corey versus Iowa had the situation where the child witness was behind a screen, and they said that you have a constitutional right in confrontation not merely to cross-examine, but actually to have a face-to-face meeting with your accuser. Maryland versus Craig backed away from that, and it said, okay, in limited situations, the right to confrontation includes not just the right to cross-examine, but the right to actually see your accuser, to have them say face-to-face, and that's an important part of confrontation. He said if there is an important public policy that could be furthered by the witness not having to face the witness, and the judge makes a requisite finding of necessity in a case-specific finding, then that can give way. So you have to have two things. You have to have an important public policy that's being furthered by the limitation on face-to-face confrontation, and the judge must make a specific finding as to that witness and that case that is necessary. And in that child witness case, it was that the child witness would be so traumatized by having to confront their molester or face their molester while giving the testimony. So what I suggested is that we put in this language that's in line 34. Well, I want to make sure we're from the current bill. Yeah, line 35. Upon a finding by the court specific to the case and the witness. That's what Maryland versus Craig requires. It has to be a specific finding that the witness would not be able to testify in person without showing undue emotion. I mean, that's the important public policy, that they not show undue emotion, which might make the testimony prejudicial and therefore violative of the Eighth Amendment rights of the defendant. Or that testifying in person will cause the witness severe. Now, we put in the word severe because that language comes from Maryland versus Craig, because they said severe trauma in that case. Severe emotional, physical, or emotional trauma. And I think, I forget who suggested we add physical. One of the members of the committee thought that we ought to add physical. Physical or emotional, thinking that a person might have a heart condition or something, and that would be such an emotional thing that they could only do it in that way. Or emotional distress or trauma. Evidence presented in this section will be in the form of, but not limited to, and so forth and so on. I think somebody suggested that maybe we ought to be clearer instead of using audio taped or videotaped, some sort of, because often this might be a digital or a CD. I don't know if we need to clarify that language. And if we want to take out teleconference, by the way, in Maryland versus Craig, that is what was happening. They had a teleconference room in another room, and they would have a feed. The lawyers were in another room, but I think it's probably helpful if we're considering that we've got a death penalty situation. We want to make sure. I think what most people believe will happen in this situation, this teleconference is just too complicated, is there'll be a video presented like we have a lot of video witnesses in depositions. And then that is provided subject to cross-examination. So I think it's probably helpful to take out the teleconference and so forth, because that's really not going to be used. So why create a problem that we don't need? And then the rest of it should be the last sentence should be taken out. I I've tried to give the committee and work with Ms. McDade and Senator Wiles about this bill to make sure it does what we all intend for it to do. Mr. Chairman, the language "or unduly burden a witness," I'm not sure what that really means as well. I don't know if that it might make sense, since we're really providing for this procedure in section 4, to take that out, because that is language that is troublesome. Does it mean that the court is denied the opportunity to frame the statement in a way that the court believes is best, because that might somehow unduly burden a witness? I don't know if that language is actually important in this bill. And I didn't even think about it until Mr. Chairman, you mentioned it. I think it probably would be good to take that out, just to make this bill as clean as possible, because Section 4 really deals with what we're really trying to get at here. I hope I've been somewhat helpful to the committee, but I do want to say that, as on behalf of the defense bar, we support this legislation as long as it's perfected the way we've talked about.
Questions for Mr. Martin?
What section? I don't have section 4 in mind.
I think he meant paragraph 4 on page 2.
Paragraph 4.
It's really section 1.
Yeah.
Paragraph 4 on page 2 of the bill, line 35.
I'm sorry. It's paragraph 4. That's the paragraph that really gets to what we're trying to get to. I would suggest, my only suggestions is that we take out "or unduly burden the witness." If we're going to change the number of witnesses, let's limit it to immediate family, and let's take out the language about teleconference and so forth that Mr. McDade said, and maybe clarify the audio tape, videotape language, and then we'd have a pretty good piece of legislation, a real good piece of legislation.
Mr. Knox.
Maybe I'm confused. Is the phrase "unduly burden a witness" referring to whether or not the court can require or permit the statement in some pre-recorded fashion?
No,
and that maybe they can't write very well, or whatever that.
No, because what we've done is we say, if you look at
what line are you on now?
I'm on. Well, first of all, let's look at line 16. 15.
Let me jump in for 1 second.
Yeah.
I think it's really going more toward the physical emotional distress. Isn't that
right.
what it's really going?
But this is in this clause having to do with the admissibility shall be in the sole discretion of the judge, and shall be omitted only in such manner and such a degree as not to inflame or prejudice the jury. That's current law, and that's required under the Constitution. Now we've added "or unduly burden a witness," and I don't know what that means, because we're really talking about admissibility at this point. If we're worried about unduly burdening a witness, being that they would be traumatized by the testimony, that's covered by paragraph 4. Okay. So it opens the door. So, well, is it unduly burdensome a witness to make them answer a subpoena?
As I read that, Mr. Chairman, it's the paragraph 3 is all going to opening the door for this victim's statement. And so if it's opening the door and making it more permissive, just dangerously thinking out loud, if it's making it more permissive for the victim's statement, one would think that by virtue of its permissiveness, it's not an undue burden for the witness, because it's the whole point of the paragraph. Is that...
maybe Mr. McDade could weigh in on this, but I'm showing these juxtapose unduly burden a witness and the admissibility of the evidence issue.
Right.
That's what we're dealing with, and I'm trying to figure out how admissibility of the evidence relates to unduly burdening a witness. That's all. I don't know. I'm not sure I see the connection.
I'll let Ms. McDade speak to it, but I think it's unnecessary, and it could cause potential problems, is what I'm seeing.
Mr. Chairman.
Yes, sir.
My position is, so long as you leave intact the findings that are required by the judge for the procedures and code, the unduly burdening the witness is not necessary. In all candor, I don't think that it's necessary on the admissibility issue.
Somebody put it in here because it's new language, and I'm just curious what the,
That was
maybe we're missing something.
that was put in there before we did some of the things we did with
Oh,
paragraph
okay.
4.
Okay, I got it.
I hate to say I think I'm agreeing with Chairman Knox, I'm not sure.
There's got to be something wrong there.
It's always good to witness those occasions when right meets left on some issues. Ms. Abrams can talk to that from our vote earlier. Yes, yes, ma'am. I understand. Any further questions for Mr. Martin? Mr. Martin, thank you.
Thank you.
Chairman Wiles, did you have a?
Well, I was just going to say that these witnesses, I anticipate probably taking 15 or 20 minutes.
Understood.
I might provide a quorum in Judy for House bills in about 6 minutes, but I'll come back. I just don't want what happened to Chairman Hamrick's bill to happen to my bill, so I'll come back. But I thought maybe there's probably there's 4 or 5 bills over there.
Let me give you where I'm at, just for purposes of planning. I think what we're going to do is we're going to certainly hear from the witnesses, and we welcome their testimony. With regard to the Sixth Amendment issues as it relates to the audio tape, videotape, that's something that I think we need to take a look at least overnight. It's my intention to go ahead and visit with council about it and members of the committee today, this evening, with the intent of bringing it up again tomorrow for a vote. I'm just concerned that we get as tight a language as we humanly can. I think there's universal agreement this bill needs to go forward. We just want to make it sure it's as perfect as we can get it. So I think that's where we're at. So I know that senators have responsibilities.
I know we have an 11 o'clock subcommittee meeting
Yes, sir.
of another bill that's important to me.
Sure, and
But
I think
why don't without showing readiness to the committee, I'll go over and provide a quorum.
not at all.
About 6 House bills.
Not at all.
Come back at 11 for the Senate.
No, we appreciate it. That's where we're going to be procedurally, and we'll. It's the intent to go ahead and bring it back up tomorrow morning with as tight as we can.
Before session.
Yes, sir. It'll 8:45 tomorrow morning.
Yeah, I don't know. I haven't even looked at the calendar.
That's all right.
But I know there's a lot of them. So what I'll do is I'll just head out over there, and I'll be back at 11.
Thank you. So we would let's take a 5-minute break for members of the committee. We'll come back in exactly 5 minutes and hear from the rest of our witnesses, which we look forward to, and we'll pick it up from there, with the intent of being concluded no later than noon, certainly earlier than that. We'll continue the hearing on Senate Bill 151.
No, I was going to say, if he has a new name, your name is Sleepy. I didn't hear the alarm. I'm glad you called. I wish I had. Slow as his head.
Let me ask Ms. Claudia Barnes to come forward. Ms. Barnes, we welcome you. Thank you for taking the time to be here and to participate in this process.
Thank you for letting us speak.
And the difficulty that that you've been subject to, both past and I know this process in the debate and going over the issue, I know, brings back circumstances that I know are painful. And,
it does, but at least we're here for another purpose now that is a good purpose for the rest of the victims to come.
Well, we appreciate that, and we respect it, and we welcome you.
Thank
Look
you.
forward to your comments, and the floor is yours.
Okay, thank you. March 11, 2005 was the most horrible day of my life as I became a victim in the most heinous way. And I became a member of a club that I did not want to join. I didn't even have a choice. It's not that I can't speak to you without notes, so forgive me for using my notes. But when you have the murder of a precious loved one, it sometimes destroys the ability to remember what it was that you wanted to express and to get your point across without breaking down or drawing a complete blank at times. And it can totally cripple your speech abilities. We have marriage and birth announcements that go out when a relationship with a loved one begins, but absolutely nothing can prepare you for the death of a loved one who's not even been sick and thus giving you some warning of things to come. As you know, the 4-victim murder trial that involved the assassination of my husband, Roland, lasted 12 weeks. The victims got about 1 day to make statements, as opposed to us hearing about the defendant the whole trial. For just a minute, if you'll put yourselves in the places of each victim who kissed their loved ones goodbye that Friday morning, and imagine how your wives and husbands would feel if they did not know until much later in the morning that you'd been assassinated during your workday as an elected official. And don't think for 1 minute that this couldn't happen to you. If it could happen to my husband sitting on the bench in a courtroom in a building supposedly secure to employees and visitors alike, it could happen in this building as well. The first 8 weeks or so involved listening to gruesome details and horrendous pictures, seeing horrendous pictures of our loved ones lying where they were murdered, seeing where the bullet holes entered and exited their bodies, as well as autopsy pictures. We also learned the devastating truth about Agent David Wilhelm living approximately 15 minutes after his murder because he was paralyzed when he was shot during his murder due to the bullet severing his spinal cord. After the first part of the trial was concluded, the victims had to read their impact statements, which had been slashed up pretty much by the defense team and the judge, I'm assuming. Our prosecutors fought long and hard 1 whole day to try to keep our feelings in our statements. They apologized profusely over and over for having to cut them so much. So they retyped them and handed them back to us in order for us to conduct a dry run before the defense team and defendant, who glared at us the whole time with no remorse on his face. We were taken one at a time to read our statements with explicit instructions to show no remorse whatsoever and read exactly what was on the page, and by all means show no tears, no emotions while on the stand. If we did show a tear or we choked up, then we would not be allowed to read our statements to the jury. So imagine how hard this was after all we had heard and seen. 2, it would be even harder for those victims who do not know how the system works. Christina was the daughter of the slain court reporter Julie Brandow. She got so nervous even during our trial run that she choked up a little bit. So they weren't going to let her get up there. And evidently the prosecution or the defense, somebody talked to the judge about it, and they made a motion she not be allowed to read a statement. But then they said that she could. Judge Botiford changed his mind. When she felt her emotion beginning to show, she took the time to drink out of her water bottle and regroup. Sometimes we had to just swallow to keep from showing emotions. And she did this, hopefully making it through without a problem so that she would have the right to speak about her mother. So how tragic would that have been if she hadn't been able to say anything on her behalf? Imagine whether or not your wives or husbands, your children, your parents, or your siblings could make it through this fiery test without breaking down and not being able to speak on your behalf, especially after hearing for 8 weeks about how wonderful the defendant was deep down. Could they do that for you? There's a very simple solution to this, and this is the victim impact video that we're talking about, which could be recorded beforehand, and they can edit it over and over to make it as perfect as possible. Then it could be introduced as any other piece of evidence to be reviewed by the judge and attorneys before trial. And according to former Judge Gino Brogdon, who also regrets not being here today, he said that once it's admitted into evidence, there would be no worry about a victim adding to the statement on the stand, and the judge and attorneys would already know that all they had to do was play it in open court during the trial in place of live testimony. So therefore they wouldn't have to worry about somebody getting up there and doing something different than what they were told. So I feel like this is a win-win scenario for all parties involved. It's already been approved by California by the Supreme Court. So please consider these feelings when you decide on this bill. And it's probably the most important one you will ever consider for the victims in your precincts. Thank you.
Thank you, Ms. Barnes. Let me ask Kelly Wiggins to come forward if she like. Ms. Wiggins, good morning. Thank you for being here.
Good morning. Thank you for giving us the opportunity to be heard. I'd like to thank those that were in the subcommittee the other day for hearing us and the work that you've done together to make sure that this is good legislation. We do want to make sure of that. My sister was 36 years old. She was the victim of a double homicide in Douglas County. She witnessed the first victim be murdered, knowing that her life would be taken next. She desperately tried to escape, only to be shot in her back. Her killer knew that she was not dead, so he executed her to ensure her death. Not only that, they were left where they were brutally murdered for 2 days. We never saw my sister, and we never said goodbye. As David alluded to earlier, my mother was here last Thursday, and my father is here today. And you can imagine the excruciating pain it would be to take a stand like this in a courtroom setting, and yes, facing the defendant and all of your family members, seated beside a judge in front of 12 people who are going to decide the punishment for this person, and hold your composure and your emotion about what you're reading. And don't get me wrong, the first option for victims is to testify in this manner. The first option would be to testify as I'm talking to you today. But we don't have that right. They do want the right to testify openly. Read their script that they're allowed by law, per se. But sometimes it's just not possible. Sometimes you just can't not cry. I don't have to ask those of you who have children or siblings or spouses to be seated in this position and read about the worst day of your lives. And I understand the videotape I understand the defense side of that, wanting to benefit them. But we're here asking you, for victims' families who could possibly be denied the right to speak on their behalf, to give them another form of expression, another way to convey the right that they have. They have the right to give a statement. Sometimes they just can't read it and hold their emotion. At that point in the trial, trust me, the victim's family, of all people, do not want to cause mistrial. That's not what you want at that point. You want to do everything that you can to convey the pain and the tragedy and the effect of what's happened to your loved one. This is a good piece of legislation. It's very good. You are enabling victims to fulfill the right that they currently have under Georgia law. We're just asking you to make it a little easier for them to convey that right. I know tomorrow you're going to get together and we're not going to be here. And you won't see us on the front row, most likely. I want you to remember these moments when we're seated in front of you. And I don't want I want it to be legally right, because I don't want it to ever come back and be a problem. But I don't want it to get sidetracked and bogged down. I'm asking you to make this happen. I'm asking you to come together as legislators, as you pointed to earlier, where the left meets the right, and do the right thing for victims of Georgia. Thank you.
Thank you, Ms. Wiggins. Wayne and Linda Brown, if they'd like to come forward. Good morning and welcome.
Good morning, Mr. Chairman. Thank you for allowing us to come before you today, and honorable committee members. If I may refer to this bill, there was a couple of things talking with Mr. McDade about, and I am looking specifically at line 19 and 20. And that is in reference to what is seen in line 13. And we're talking about the witnesses. So we're saying in one case that the court shall allow evidence from the family of the victims or such other witnesses having personal knowledge, and etc. My real concern here is that when you move down the line 19 and on down to line 20, that now all of a sudden the sole discretion whether or not a witness is allowed to testify is the judge's discretion at this point in time. Now, Mr. Martin also spoke to this. We don't have a problem with that when you're talking about outside the immediate family, because the witness list could go on forever in a day. That's not an issue. What I would humbly suggest as a layperson is that we add 3 words, and this I'm sure that Mr. McDade and Mr. Martin will work this out along with you committee members at a later date, but what I would offer as a simple alternative to this is on line 19, right after the word witnesses, is simply the 3 words outside immediate family, or maybe 4 outside the immediate family, who may testify. So therefore, then we would say that the number of witnesses outside the immediate family who may testify shall be at the sole discretion of the judge. Now we're limiting the number of witnesses, but we're not limiting the opportunity offered to the immediate family. That is one of the concerns, and I think that is real important, that this bill be worded in such a way to allow the immediate family members the opportunity to testify during the sentencing phase of the trial. If I may, Mr. Chairman, on page 2, I would offer, and I'm just an engineer, I'm not a lawyer, but I would offer on line 39, having worked with, I'm a double E, so having worked with a lot of electrical, I would suggest that if you just remove audio tape, replace that with audio, replace the word videotaped with video, and then precede that with the word pre-recorded, so that then the statement would read, starting on line 39, statement, comma, a pre-recorded audio or video statement. And then that takes care of all the recorded media, whether it be a CD, a DVD, or indeed a tape. Again, just a suggestion, but thank you for for listening. But my real important issue is on page 1 there, not to exclude the witnesses. I think that is vital. I think this is indeed a good bill. I think you, ladies and gentlemen, have an awesome opportunity before you to help future victims in the great state of Georgia. This is too late to help my family and me, but it's not too late to help those future victims who will endure the agony of the trial, not to mention that terrible agony that they have gone through and will be going through during the trial. To get to our trial, it took us almost 4 years. That's a long time to endure the agony. And I can tell you, when you're sitting there, you and I could discuss, and before this committee, technical points all day long. We could talk about various issues. But as Mr. McDade put it so eloquently, when you're talking about the loss of your baby girl, that child that you held and watched her open her eyes for the very first time, that you protected during her entire life. Ladies and gentlemen, it gets real personal, real quick, and it gets real emotional. And all of a sudden you find yourself entering unfamiliar waters. All the committee meetings that you've been in, all the presentations that you've given, all the questions at the various presentations that you've endured. You wonder, my God, what happened to me? And what happened to you was you lost your baby girl. And Mr. Chairman, I would say to you, those of us that have been on that witness stand, did we choose personally to do that? Yes, we did. But we didn't place ourselves in that situation. It was that convicted murderer that placed us there. You know, Mr. Chairman, committee members, my dear old mama used to tell me, and yes, I still call her mama. I'm just an old southern country boy. My old mama used to tell me, Wayne, you know, son, if you'll stay out of the courtroom and out of jail, you'll be all right. And I've tried to do that most of my life. And I found that to be very, very true. But all of a sudden, you find yourself in this courtroom, and you find it because an individual has blown the brains out of your baby girl's head, to put it in a vivid manner, because it is no more vivid than that. That's how real it gets. We're comfortable here today. We're relaxed. We'll go have a nice lunch in a couple of hours. You'll go home to your families this evening. But just imagine the thought, and as Mr. McDade said, just the mere thought of going home, and I pray to God this never happens to anyone in this room, and the police knock on your door. And they tell you that your baby girl won't be coming home. She's been brutally murdered. Ladies and gentlemen, this awesome opportunity that you have to help future victims in our great state is before you. And I plead with you this morning to please take the appropriate measures necessary and send this bill forward. And again, we do thank you for being meticulous. I think that is important, Mr. Chairman. And believe you me, we really appreciate it. If we may, I think my wife Linda has a few words. Thank you.
On September the 13th, 1982, my daughter, Lori Kathleen Brown, was born. She weighed in at a healthy 10 pounds. She was an outgoing kid from the moment she was born. It was just amazing. At 18, she graduated from high school, and in that same year, she also received her real estate license. At 20, she bought her first house. At 21, she became engaged. And on November 3rd, 2003, at the age of 21, she was brutally murdered in a double homicide. On a beautiful sunny day, in a nice area of West Cobb, she was working in an on-site sales office, and a man walked in her office and murdered her partner. And as she came in on what was going on, she was also murdered. From that day on, our lives have never been the same. We have gone through the worst thing that a parent can possibly ever imagine. The worst words that a parent can ever hear are that your child is dead. Your child's been murdered, and for no apparent reason other than a robbery. And you try somehow to put the pieces together and to go on and try to keep your family together and hold it together, because at that point you're not sure what's ahead until you get into the process of going through the motions and the hearings, the numerous hearings, to try to bring this person to trial that's accused of murdering your child. And then you get to the end of the road, so to speak. You reach that point where the trial date is actually finally there, almost 4 years later. And you've prepared this statement. You've tried to sit down and put into words how this has affected you, how this has changed your life, what this has done to your family. How will you go on? How will you face everyday life? You know, and it affects everybody is affected differently. Only by the grace of God, I can tell you that I sit here today. I know that without a shadow of a doubt, had it not been for my faith, that I would not be here today. So I prepared my statement about my daughter and went into that courtroom, and I was asked the questions, and we went through the process trying to answer, or trying to read our script, our words, and it was the most difficult thing beyond putting my daughter into the ground that I've ever had to do. I was able to do it. Not everybody can. And I can tell you from experience, not everybody can do it. They just can't. So I'm humbly asking you to please pass this legislation. Make it easier for those that follow behind us. Let them have just a little bit better situation than what we were faced with. And there will be others that we all know there will be others to follow behind us. I mean, they just will. So I'm asking you as Lori's mother. I'm asking you as a mother that sat in that courtroom and had to read the words about my child and try not to be emotional about it. I'm asking you to please consider this. Do it for the ones that have been lost already, but do it also for the ones that's coming forward in the future. Thank you.
Thank you both for your testimony this morning. Ms. Jesselyn Dorsey. Come forward if you like. Ms. Dorsey, good morning. Good morning. The floor is yours. Ms. Dorsey is the final witness, and Ms. Dorsey has the last word. And if you wouldn't mind just bring the microphone a little closer to you so the folks watching can hear you.
Okay.
Thank you.
To the chairman and committee members, first I want to thank you all for allowing us to come before you again, before the full committee, and thank you for those that were on the subcommittees that have listened to us. I am a victim, but now I actually consider myself a survivor. On October 3rd, 1999, my only child was murdered in Cobb County by two young men that did not even know him, outside of a Sweet 16 birthday party. My son was 19, getting ready to graduate from high school. He was actually running away from shots that they were shooting, and he got shot in the back. It's the hardest thing in the world to receive a phone call and a knock on your door, as others have said, that your child will not be coming home, that he's been murdered. I had seen that happen to other people on television, radio, and never in my wildest dreams did I think I would become a victim. This is not an easy task. It's not an easy journey. It's very hard to live every day when you had so many hopes and dreams for your child. I will never get the opportunity to see him being married, having grandchildren. So now I'm like a surrogate godmother for a whole lot of other people's children and grandchildren, which helps me in some regard. I ask that you pass this bill with the amendments that are so rightly needed for victims. Like I said, it's been 9 years, and what I do now is I speak at schools and churches and counselors and anyone else that will listen to let them know the impact that these crimes and homicide actually have on victims and their families, the communities. All of us here today stand before you not by choice that we would have made, but because we want to help others. As Wayne and his wife said, those that will come behind us. I hope no one else has to walk in my shoes. I pray that every day that some other parent would not have to go through what I've been through. But again, I hear it every day. So I'm asking you to help there be another way for them to deliver their victim impact statement. It's very hard. In my profession, I speak all the time before countless people, hundreds of people, and it's easy. But I still get choked up, even speaking before a small committee sometimes when I'm speaking now for the voice of my son and other victims. It's hard to write that statement. I tried preparing my statement so many times and could only get a sentence or two without a tear dropping on the paper or crying. My mother wanted really bad to give a statement, and she tried so many times to write, and she couldn't. But if somebody had asked her, can you speak about Terrence, she would have been able to record a video. And I wish we had had that opportunity. Like Wayne said, it's too late for me now. I've given my statement, but I actually garnered the strength and the will to do mine on the memories of my son, knowing that I'm the only voice that can speak for him now. Others that I talk to in our victim support groups, they have a hard time doing that, and they still can't do it. They have the fear of the courtroom. They don't want to look at the defender. But again, they want to be able to voice their opinion. So if they had the opportunity to actually put it in a video statement or audio statement ahead of time, I'm sure many of them would actually do that. Like I said, today I am asking you, not for myself, but for other victims, to help us change the laws that would be right for victims and to come together. As I said, I don't wish this on anyone else, but I know that it's something that we need. So again, I ask for your patience in working through the law and your consideration to change the law. Thank you.
Thank you, Ms. Dorsey, for taking the time to appear this morning.
Okay.
We appreciate it. With that, the hearing on Senate Bill 151 comes to a conclusion. The committee will meet tomorrow morning at 8:45. It's the chair's intent to have a substitute ready for the committee to consider and to vote on then. That's the intent. We'll try our best to get there, and we'll just leave it at that. The full agenda will go ahead and be sent out upon conclusion of the Ramsey Subcommittee's business this morning and or this afternoon. Yes, sir. Sure. Well, I appreciate that, but we're not the ones to be thanked. We're adjourned.